Welcome to our Spark TS webinar series. Today we will be talking through mastering DOT and non-DOT drug testing laws and adapting to our evolving marijuana laws. I just want to clarify that this is for educational purposes and not for legal advice. Again, if you've got any legal questions, we definitely encourage you to talk to attorneys and things like that. But we're giving you more of a broad overview of the regulation. Please don't go, hey, Holly said this and this is a state law. Use it as information and educational to go ahead and build on your program. But wanted to just get that out there. And as a reminder, Spark TS, we are a third-party administrator. We're here to help you through any regulatory issues. We are a full-service clinic, lab, and MRO. We do random pool management and consortium management and help with policy and compliance. We have on-site and clinic testers all across the country. We have about 4,000 clinics we work on. And our software system, which is called RailTasker, is pretty amazing. And our RailTasker system has the electronic document management and allows you to manage your drug and alcohol program through our software services. I wanted to introduce, I can tell you who I am. I'm Holly Rainwater. I am the Vice President of Drug and Alcohol Testing here at Spark TS. Katie Enoy is our founder and has been a very instrumental in the railroad industry for especially 243 regulations. But we came and brought Spark TS, the TPA, to Spark TS. Actually, it's been 2 years now. So we're celebrating our 2-year anniversary for our TPA services and are very excited about that. All right, I am Holly Rainwater, and I've got with us Georgia Bowen-Waddles. She is our TPA program manager. She's going to help us weed through any questions that may come up. I thought it was important to talk through what a Schedule I drug is and what other drugs are before we really got into the evolving laws with marijuana. It's important to understand that the Department of Health and Human Services tells us what drugs are Schedule I, or what are 2, 3, 4, and 5. The Controlled Substances Act classifies those drugs. Schedule I drugs have a very high potential for abuse, and they create severe psychological and physical dependence. As you go down that schedule, that changes. We go to Schedule II. It still has that opportunity for abuse, but it lessens the further down you go. And Schedule V represents the least potential for abuse. But if we drill down in there, Schedule I is a drug that is also illegal to use or possess under federal law. What that means is you can't go to the store or go to your doctor, and get a prescription for some drugs. Cocaine, for example. Cocaine is a Schedule I drug. Okay, you can't go to your doctor and say, hey, I've been really tired. Some cocaine would really help. You can't do that. And that's so important to remember. That's what a Schedule I drug is. It's illegal to use or possess under federal law. Okay, and remember, federal, not state, federal law. Okay, marijuana is a Schedule I drug. What's important to note, that's important under federal law, it is prohibited. Schedules 2 through 5 are a lot of prescription drugs that we'll talk through. And the Department of Health and Human Services, who manages these controlled substances, they actually do make and evaluate these recommendations on an annual basis. So it's not just willy-nilly, they are reviewing these on an annual basis. Let's talk through a Schedule I drug. Okay, it's got a high potential for abuse. There's scientific evidence for this. There's knowledge of this issue with drugs. There is a pattern of abuse. There are definitely significant signs of abuse. There is a risk to public health. Imagine if we gave everybody, if LSD or something like that was legal, what that would look like. And whether the substance is immediately a pursuer of a substance already controlled under the subchapter. In addition, drugs with no currently accepted medical use and a high potential for abuse. They cannot have a prescription from a healthcare provider, and it's illegal to possess under federal law. Some of these are heroin is a Schedule 1 drug, LSD, marijuana, ecstasy, methaqualone, peyote, any of those drugs, cocaine. You cannot, just think about it this way. You can't go to your doctor and ask your doctor for that prescription. Then you can't take that prescription and go through the Walgreens pharmacy and get it. Okay? That's the way I look at it, the easy way to look at it. Now, when we look at a Schedule 2 drug, these drugs also have a high potential for abuse, but they are tightly controlled, and you can get a prescription for these. Like a Schedule 2 might be like a Vicodin, okay, oxycodone, codeine, amphetamines, morphine, fentanyl. These, if you take them on a continual basis, you could become very addicted to them. And that's our opioid epidemic really falls into this place where, our doctors used to go and write prescriptions for, golly, 50 pills. And we found out finally that was not a good thing to be doing, that it is more controlled. Schedule 3 goes down a little bit deeper with a moderate to low potential for abuse. That's our barbiturates, our sedating drugs. They have less potential for abuse, like Tylenol with codeine. Okay. And then we go further, then we've got the Schedule 4. These are more, a little bit minor. They're more like for sleeping, Xanax, Sona, Darvocet, Valium, those type of things, Tramadol. And then Schedule 5, these have a less potential, and a lot of these you can actually buy over the counter, like for your antidiarrheal or chronic, some small pain, cold, cough, fibromyalgia. So those are things that you can get over the counter. When we look at those, again, the thing to remember, as long as the drug is on a Schedule 1 list, it's prohibited under federal law. As a DOT employer, if you have employees that are subject to DOT testing, they are covered under Part 40. And those people would be like our pilots, school bus drivers, truck drivers, train crews, mechanical crews, pipeline, ship captains. That entire area is covered under DOT. Part 40 under ODAPSI tells us how to conduct drug programs. It has the agency-specific rules. 219.1 is railroad operations. You've got 382, which is FMCSA, 655, FTA, 120 is aviation. So those are still saying this is the federal part that you are required to handle. Okay, now when we start looking at marijuana, we understand now it's a Schedule 1 drug. However, if you cultivate, you use it, distribute it, it's a violation of federal laws, okay? But what happened in 2022 is President Biden, he said, hey, we want to start doing an inquiry on how is marijuana scheduled under our federal law. You might be hearing a lot about, oh, we're worried about marijuana becoming a Schedule 1 drug. There's a lot of things going on behind the scenes that, Department of Health and Human Services, they're going in there and verifying if it would be safe to have this as a Schedule perhaps 2 drug or whatever schedule they would put it under. The problem is also we start looking at states, okay? Now we've got state law that comes into play. Now what states are doing is they're legalizing it for either recreational or medical use, and that truly is a conflict with federal law, okay? Now we've got a conflict between states and federal laws. It can, as an employer, be very confusing, okay? The federal government usually takes a hands-off approach to marijuana enforcement in the states where it's legal. They're not going in and say, hey, state of Minnesota, you can't do that because this is your state law. We're going to supersede it. Federal law is staying separate from that. There's also a portion of the laws that are changing where we are decriminalizing marijuana. And that's really the reduction of the penalties for certain criminal acts where it could have been a felony. Possessing marijuana in the past maybe was a felony, And now people, they're going in and saying, okay, maybe if this is your first time, you know, maybe you don't have any jail time. It just goes on your record. A lot of states are taking a look at that and removing some of those penalties. And a lot of people are saying that's like a middle ground between full-grown legalization and a strict punitive policy. That's one way that some of the states are trying to find a balance with marijuana and federal laws. And when you look at marijuana, it comes from the stevia plant, and there's different components of marijuana. Okay, so there's a THC component of marijuana, and that's your psychoactive component. That's the part that gives you the munchies, makes you feel very relaxed and lethargic and sleepy. And then there's other components like cannabinoid, CBD. We'll talk about that a little bit later, but CBD does not have the psychoactive component, and they say that like CBD oil and those products can help with chronic conditions like migraines, epilepsy, depression, so on and so forth. To recap, marijuana is a Schedule I drug with a high potential of abuse. There's no accepted medical use. It lacks accepted safety use under medical supervision, and all those states have legalized it. It's still not authorized under U.S. federal drug for any use. Let's see what we're doing as a country. This map right here constantly changes. You could go tomorrow and maybe it's changed. But today, when we look at what's happening in the US, we've got 24 states that have legalized recreational marijuana. You can actually go and purchase marijuana at a dispensary. 38 states have authorized the medical use of marijuana. We'll talk about that a little bit more, but that seems to have been around quite a bit longer. The recreational use, really, California really led the way on that, and Washington was there as well. But this is constantly changing. There's also some laws out there in regards with CBD and THC that you're going to want to be aware of. Definitely stay abreast of your ever-changing state laws. And if you're working in different states, maybe you've got locations all across the country, you might want to double check what's going on in those states and what is their law. With medical marijuana, Department of Justice came out and did put a statement out about medical marijuana, okay? It's still prohibited. It's still marijuana. You cannot get a prescription for marijuana. A doctor could give you a medical explanation, not an explanation, excuse me, a medical like recommendation. They may say, have you thought about this? But you're not going to get a prescription for it. And if you are using medical marijuana and test positive, it's a DOT violation. It's not going to change the way that the DOT looks at your testing. Again, physicians can't write a legal prescription, only recommend, and it's prohibited by all DOT agencies, regardless of state laws. And a lot of people will say, Holly, how do you feel about medical marijuana? I don't go into that, but what a lot of people say is it really helps with certain conditions. If I've got cancer or severe seizures, it really helps, they might say. Look at your state law on that, but I would tell you in those situations, if you've got, let's just say you've got a truck driver that comes to you, or a flight crew member that comes to you, and they say, hey, I'm taking marijuana for my seizures. It's at that point you want to say, hold on here, let's consider the diagnosis. Okay, not that you're taking medical marijuana, but you're taking that medical marijuana for a condition. So you maybe want to look at a leave of absence or short-term disability. And, this is where it comes into things to think about is, do you have a duty to accommodate that? If you've got people, in your company that are using marijuana, do you have a medical requirement? Do you have a requirement to accommodate them? Those are things to think about, and your state laws will be specific on that. And then the cannabinoid piece I talked about, it's the non-psychoactive component. If it's extracted from hemp, which is a non-psychoactive, it can help with anxiety and pain. But if CBD is extracted from marijuana, not hemp, it's a Schedule 1 drug. What that means is CBD products may definitely contain some level of THC. If you go to the gas station and buy a pack of gummies or whatever, you're buying a chocolate and it says it has no THC, but it has CBD in it, be very careful because these products are not covered and not regulated under the FDA. Nobody's watching what's happening in that. And if you're taking that or your employees are taking that and test positive for marijuana, you don't downgrade that. That's still the presence of marijuana. One thing I strongly encourage you as employers to do is educate your people about cannabinoid and medical marijuana. Okay. If you're doing these things, you are putting yourself at risk for having a DOT violation. When there's not that stringent oversight, if somebody says it's got 0 THC in it, it's probably not going to be accurate. The strength of the CBD and the amount of THC definitely varies from product to product. And looking at some of these products, all of them have at least a 0.3% THC in them. Okay. Will a 0.3% THC, if you take that once, make you test positive? I would think not, but there's so many variables. How do you know it's a 0.3? How do you not? It might be 30%. There is no government oversight. You have to be very careful and tell your employees they need to know what they're putting into their body. Okay. CBD is not approved by the FDA. There's one type of CBD that's approved, and it's called Epidiolex. Okay. So that is used for children with seizures. If you've got an employee that meets the requirement of being a child and having seizures, then that might be something they could have that, but typically we don't hire children. So that I would say that's probably not going to be a prescription you would allow. And then the Office of Drug and Alcohol, again, says it's unacceptable for safety sensitive to use it. And really, it can give you a positive drug test. When we go back to looking at marijuana, I want to take a look at some of the different states because they're ever evolving and all of the states are different. Again, this is not your DOT employer. This is not DOT, FRA, FMCSA, pre-employment drug and alcohol testing. This is not random testing. This is not FMCSA post-accident testing. These are your non-DOT positions. Maybe your non-safety sensitive people would be covered under these state laws. California has been in the news a lot lately. On January 1st, they made some changes to their drug laws where it made it unlawful for employers to discriminate. Whoops, excuse me, I went too far. To discriminate employers and applicants just because they had engaged in off-the-job marijuana use, unless the individual holds one of the exempted roles. What that means is if I was a secretary, we'll just make it up. I'm a secretary. I go to work in California. I'm not safety sensitive. They give me a pre-employment drug test and they say, oh, Holly, we can't hire you because you tested positive for marijuana. That would be a violation of their state law. What a lot of people are doing is pulling marijuana out of that panel. However, again, they hire me as a truck driver under FMCSA. These rules don't apply. It's covered under DOT. One thing to look at if you are going in and charging an employee with a violation for marijuana under your company authority, a lot of the states will actually, inside of their policy, note that the DOT drug testing is excluded from the regulation. And you see here a lot of people, they've been using medical marijuana for many years, and recreational marijuana was legalized in 2016, but they've just added on top of their current plan. The thing is too, this is where you want to look at the regulation And there are specific jobs where it says you can test for marijuana. Okay. If you're in construction and building trades, you can test for marijuana if they're not covered under DOT. Look in there who's covered. Okay. And really, this was just created under the Fair Employment Housing Act so that we weren't discriminating people for using marijuana. Washington made some changes. Again, may not discriminate in the initial hiring, okay? They're saying you can't use cannabis on the job, or you can use cannabis off the job and away from work. And you can determine if you cannot discriminate somebody if there was non-psychoactive cannabis in the hair, blood, or urine. The thing about that is how do you determine if it's non-psychoactive? It really doesn't break out that far. You have to be very careful about that. A lot of your urine drug tests aren't going to tell you it's non-psychoactive, but an oral fluid test is going to shorten that window. A lot of companies may be moving to more oral fluid testing for their company marijuana, just to break down that window from maybe chronic use of 30 days to recent use of maybe 2 or 3 days. Their laws really only cover pre-employment testing, and the intent is to restrict job opportunities based on their past use of cannabis. Maryland has some changes too. You can now purchase, possess, and use a small amount of marijuana and cultivate 2 plants. It doesn't address any workplace issues, but employers can implement policies that prevent the use in vehicles or at work. You can't smoke or vape, prohibit work. There's no provision in the law that restricts an employee's or employer's ability to test. It just really is there. It appears that many employers may continue to prohibit marijuana use by employers, not only in the workplace, but off duty as well. Their laws aren't as strict. The key to remember here is what you should have is your policy. What is your company policy? A little bit further down the line, I talk about the importance of taking your policies and separating them out. If you have an FMCSA policy, don't commingle that with your company policy, because then you've got a big discrepancy. Because if all of your employees are covered under one policy and you've got a clerical person that's not covered under DOT, they might think, oh, I can't use medical marijuana. They're discriminating against me. There's a lot of things to look at. Be very aware that you may need to be looking at your company policies and rewriting them. Minnesota. Now I'm very familiar with Minnesota because that's where we are operating from. And a lot of people don't know this, but Minnesota's drug and alcohol laws are very complicated. Not just in the fact that a new regulation came in where we should not be discriminating people for using marijuana on a pre-employment drug test, but it has a lot of other very restrictive portions of the law. Medical marijuana became legal in 2014 here in Minnesota. In 2022, Minnesota legalized some recreational use of hemp, so like our CBD, with less than 0.3% THC in it. And then we had the recreational use change on August 1st. Some of the things that Minnesota says is that as a company, and if you're in Minnesota, you have to have a written policy. It actually states you have to have a written policy. And this policy is outlined in the regulation in the Minnesota law that says you got to say who's going to be applicable for testing, what kind of testing they would be subject to, if they refuse to test, what happens to them, what disciplinary action or adverse action is going to take if they have a confirmatory result, the right of this employee to explain a positive test or other appeal procedures. The policy must have the alcohol policy written out. It must be posted, and also that your employees have to acknowledge it. If you're in Minnesota, you have to make sure that if you're doing non-DOT testing, your employees have to acknowledge that. Some best practices are maybe in the hiring process before they take that pre-employment drug test, if you're having them take that. Put in the policy and have them acknowledge that they received the policy. One thing this talks about, this slide here talks through reasons for testing. The reasons for state testing are completely different from federal. If you've got your federal hat on, okay, take it off because these are completely outside the box, okay? It's like in Minnesota, we have job applicant testing. There's physical exam testing. If somebody's going in to have an exam, you can test them. I think it's no more than every 6 months, but you have to give them a 2-week notice if you're going to do it. With random testing, it has to be for certain positions. If somebody has gone through and they're in a treatment program and they have specific rules on follow-up testing, that falls in there. And really what they're saying is you just can't test because you want to, okay? Cause testing, reasonable cause testing, has very clear definition in there as well, that you have to assume that they appear to be under the influence. So it really looks at their cause testing under a suspicion umbrella. And I think one of the things here is and if you're a DOT employer, think about it this way. A lot of the state laws were written knowing that some employers are getting these test results back, but they're the lab results. They're sending employees in and the lab is telling them what the result is. They have that screening test, right? They're actually not going through an MRO. With that being said, they may get something back. It says, oh, positive for hydrocodone. You're done. I'm not going to hire you. But it didn't go through that whole MRO procedure for them to verify the prescription. Okay. So a lot of the laws, think about that, is that maybe when the law was written, like in Minnesota, it doesn't think and walk through the MRO process like DOT does. It really says you can't just take a screening test and, give a violation off that. You have to actually go in and do a confirmatory test to make sure that it does meet the requirements of a positive drug test. One other thing that Minnesota does is you cannot discharge an employee if a positive result comes back on a confirmation test if it's a first-time offense, okay? You must give them the opportunity to obtain treatment and successfully complete the program. Now, if they don't do that or they refuse to do that, then you can terminate them. Now we've got DOT laws that say you can do whatever you want with them, right? You can terminate a positive DOT test, okay, technically under the rules because it's silent, right, on what you should do. But in Minnesota state law, you cannot terminate somebody with a first-time positive test. Think through those things. You might have two different things going on. Some carriers may say, okay, we're just going to follow that. We're going to give everybody a second chance, even if it's federal or positive. Some people don't. You've got to look at those things very carefully when you're looking at your program. Other things to think about when we're going in drafting your policy, look at who you're testing, okay? Are you testing employees? Are you testing applicants? Are you testing contractors, okay? And why are you testing, okay? Are you just testing because, okay, that's what we've done for years, so we're just going to continue to do it? If you weren't on our webinar last month when we talked about knowing your numbers, it's a good webinar to go back and look at because you need to understand what's happening in your company. Definitely take a look at who you're testing, why you're testing, and then look at the drugs you're testing for, okay? Many companies with these very restrictive state laws are actually removing marijuana from their panels if it's a non-safety sensitive person, okay? And definitely draft a legally compliant policy. Work with an attorney. Let them know, here's what we do, here's where we operate, and get that policy out there and then follow that policy. A lot of these state laws have notices on what you have to do and where you post. Okay, you have to post your policy. A lot of people will say you need to find a place where do I get help? If I want to get help, where do I go? Should be on your posting. Satisfy the pre-employment acknowledgement, okay, like Minnesota. You've got to say, hey, I understand, I'm going to test, okay? I've seen the policy. You have to have all of that information. If you're doing random testing, make sure you have a scientific procedure. Don't draw out of a hat, okay? And make sure you're testing the right people according to the state law. If you are doing non-DOT testing and not using an MRO, I definitely encourage you to get an MRO and following the laboratory and MRO procedures as highlighted in Part 40 under the DOT regulations. The nice, clear, concise process. Again, a lot of states don't talk about that. You may see screening test a lot. That just is a screening test. That's not a confirmatory test. You want to have all of your consent forms. Minnesota, for example, has a lot of this information on their website. You can actually use some of the information that they have available. You want to also recommend in Part 40, it says you have to have a DER, right? A designated employee representative who manages the program, removes people from service. For company testing, I would encourage you to do the same. If you're not doing DOT testing, or if you only do DOT testing, definitely take somebody and have that person manage the program, manage the compliance. You don't want to find out that people are just going to the clinic and testing for whatever reason, because you could put yourself in definitely a legal issue. And it surprises me how many carriers have only one drug and alcohol program and they're commingling that non-DOT and DOT programs together, but separate those. They're two different types of testing, okay? Separate those policies. It's definitely a recommendation that I would have. Stay abreast of your laws, keep up with, and DASA has a lot of laws out there. Your TPA is probably telling you, here's what laws are going on. Audit your policies. If you're in Minnesota and you didn't change your policy in August, you need to take a look at your policy and see what you're doing. Same way, look at Washington and all these other states that are changing their laws. Know what's going on. If there are, you want to go into and say, hey, here's where you can do marijuana off duty, but you can't do it at work. You want to have very clear recommendations in your policy and requirements in your policy have in there. You cannot, marijuana is prohibited on duty. You cannot possess it in the workplace. You want to be very clear of your policy. Also, train your supervisors, right? Train your supervisors on the policy. Train them to know what signs and symptoms of drug or alcohol use look like. All of the DOT modes say, here's a supervisor training to understand, here's what alcohol use looks like, here's what drug use looks like. Train your supervisors on, because if somebody comes to work and they're impaired, that's a suspicion test, right? That person could be violating your policy. Make sure that they know that under the state law probably is going to be an acceptable reason to test. And also be mindful of other laws, right? An example would be federal law, company law in regards to, like in Minnesota, you can't terminate a first-time positive, but on federal you can. How do you want to handle that as a company? If you're headquartered in one state, but somebody lives in the other state, how do you handle that? Work with your attorneys to determine if having one policy that oversees everything, that maybe it's the most restrictive, just really on what to handle there. I guess I will click it back over to Georgia. I don't know if we have any questions. Do we have any questions that came in, Georgia?
We have one concerning CBD. What if I have someone who takes CBD, would they test positive?
That's a very good question. The answer is so clear, and it depends. It depends, because it depends. It's not federally regulated, but depends if that person is using a CBD product that has THC in it. Again, it's not under any federal regulation. It's not being scrutinized. It's not being reviewed by any agencies. It's used at your own risk. They come up with a THC in that, then they are a positive test. How about other questions?
No other questions at this time. They're working on sending them in.
Really, a key thing to do is definitely educate your people. Okay, let them know what your policies are, let them know what their options are, and go in and constantly be on your tiptoes about what's happening with the policy. Because if the state laws are changing and you're not changing your policies along with it, you could have some issues. Leverage your tools, right? Leverage what you have, for instance, maybe in that hiring process, like I talked about earlier. If they have to verify that they've seen the policy, put that in the hiring process. Have that be part of the next step when they go in to do the drug screen. Have them acknowledge that they've seen the policy. It's a lot of things that you can do to be proactive, and it's just thinking outside of the box when it comes to those things. Any other questions? We good, Georgia?
We're good.
All right. We've got some pretty exciting webinars that are coming up. I would encourage everybody to go to our website at www.sparkts.net for our upcoming webinars. Check us out on LinkedIn. We post our webinar schedules there. If you have any questions, please feel free to reach out to me directly. I'm at holly@sparkts.net, and my phone number 612-501-5671. Definitely reach out to me. If we don't have the answer, we're going to find you the answer. But we encourage you to stay abreast of all the state regulations. Definitely, if you've got ideas on future webinars that you'd like to see, let us know. We would love to bring forth what you are wanting to see. And I still love this picture. This is our team picture, our Spark TS team. We're really excited to have the opportunity to partner with our clients and with you in regards to TPA services or other services in regards to training and compliance. I hope you have a safe day, and thanks for attending.